This podcast is brought to you by the School of Advanced Study, University of London.
Okay, before people get too restless, let me introduce the second panel. We have, I'll just go in this direction, but it's not necessarily the direction in which people will speak. Lutz Ott will be the discussant for this group. He teaches human rights at SOAS, until very recently was working for many years at Redress. Does a lot of work on Sudan. I don't have a deal with him, I promise, but the second edition of his human rights textbook is coming out next year. And it's actually the only textbook I know on human rights that has a section devoted to human rights defenders. So credit to you for that. Let's hope more pick up on that, okay? And then we have Enrique Eguren from Protection International. We have Champa Patel, still from Amnesty. We have Martin Jones from the Center of Applied Human Rights, an erstwhile colleague. And then finally, Karen Bennett from London Met's Center for Human Rights and Social Justice. So we're going to go, I think, in the order, well, we'll start with Enrique and Champa. And you're welcome to sit down or come up as you like.
No, I think, can everybody hear me okay? So I'm going to just contextualize the article that we wrote and why we thought it was an opportune time to look at how we recognize human rights defenders. So I'm sure everybody is aware we're in a context where we're seeing increasing legal restrictions on human rights defenders and broader civil society. This is often done in the name of security. So I think what is interesting to think through is the new laws that are currently being passed, whether that's the cybersecurity laws in China, through to things that may seem benign, such as the UK Lobbying Act, but that ask defenders and broader civil society to document what they do, how they do it, how many hours they work on it, reflect a really worrying trend for us. So we thought, what does it mean to actually recognize a human rights defender? And what we've also seen is the use of existing laws to criminalize defenders. So the use increasingly of less majesté laws in Thailand. So for example, I don't know if people saw recently, but the New York Times was published in Thailand with entire articles blanked out, where they were critical of the Thai authorities. So where there are laws that exist that are not around actually the practice of human rights defense, but they are applied in such a way that also then criminalize human rights defenders. We see this in Malaysia with the Sedition Act. Amnesty is working on a case at the moment of Zunar, a cartoonist who is in prison for essentially tweeting. So we think these are worrying trends. And an attempt to define human rights defender work in a very narrow way, which reflects, for us, has implications for then who is deemed worthy of protection. So I think this article came out of a context in which we were observing these trends and wanted to think through, well, what does it mean to recognize a human rights defender? And what we tend to do, as has been mentioned previously, is look at international standards, or how do regional bodies or mechanisms understand them. And we felt very much there needs to move to a shift to understanding practice. So we should recognize human rights defenders by their practice, relational to their context. So I'll hand over to Kike now and can talk a bit more about that.
Thank you. From this point of view, recognizing defenders as bodies, in the first place, people. Bodies work and interacting with the community, but also with the wider community, international community, struggling with local norms and culture, and struggling also with international standards and norms. So they are at this interplay. From this point of view, we think that defenders are also bridges, sort of. They have also to interact with the state, but also with civil society organizations, international organizations. So we think that defenders are not an object of protection from this point of view, but they are subjects in construction. And then the question sometimes when we discuss in the article, do defenders exist as such? We have an idea of a defender as a fixed person, a rational person making rational decisions in charge of everything around his or her work, or are defenders like subjects in construction? They are being affected by the power dynamics at play within the particular niche space of work. So they learn, they suffer oppression, they try to build bridges, they try to do their own work, sometimes defense of human rights, sometimes something else. And at the end of the day, all this shape their practice, and we come back again to the practice. But according to this practice, it's really difficult to standardize the practice. Saying that defenders, we agree with the of course, with the UN approach, saying that defenders must recognize the universality of human rights. They must work in a peaceful way, let's say. Those are two conditions and standards, but then when we look at the actual work of defenders, we have questions in terms of do they exist. For example, for perpetrators, defenders do not exist necessarily. We talk about defenders, it's a related practice, but perpetrators see troublemakers. If they hear something about defenders, well, this is not with us. We are targeting them because they are affecting our real work. So this is our business, not defenders. From the point of view of states, sometimes when we look at the laws being approved in Latin America and also now in Western Africa about defenders, defenders is about individual, not collective bodies, individuals who engage with nice work about human rights, so rights of children, rights of women, it's quite okay. But if they start discussing collective rights about property or territory, land grabbing, they become troublemakers again. And sometimes states look the other side, especially governments, involved governments, look the other side to avoid engaging with them in the protection. Even the same thing about civil society, maybe all of us. When we talk, for example, about the risk approach to the security of defenders, which is a well-known approach in terms of assessing the risk, we always have this positivist top-down approach. So defenders, again, are rational individuals who can evaluate the risk, assess the threats, assess political capacities, and make decisions. This is not true. And we know that this is not true. So are we approaching defenders as an object, a non-existing one? Maybe a few men who are lawyers in capital cities, but not the rest of the people? Or should we change our approach, shift it, and then look for those studies in construction and become in place ourselves that with this omniscient position about defense of human rights and change it by a position slightly just by defenders, try to understand the reality and then making sure that each of our protection activities respond to this reality, to the precariousness of the work and not to this like positivist approach to the resistance, to the identity. So these are reflections of our practical knowledge.
I think one last point we would make, if we may, is that we often talk about how localized human rights practice is the practice of translating and framing international standards. But everybody translates and frames. So it's understanding that this isn't a hierarchical relationship, but it's a constant reformulation by all parties who are part of this, because everybody is adapting, framing, translating. So it's understanding that local practice isn't just the defender in their context. Everybody is part of that reframing. So we thought it was very important to move away from this idea of criteria, standards, to think about what are the challenges that people practically face when they're trying to do their work, and understand that in order to develop effective protection plans. And that was the only way that we thought you would really truly address the protection needs of communities.
Thanks. Karen?
Hello everyone, and thanks for coming to the launch. I just wanted to thank the University of London and actually the team of the International Journal for Human Rights and all of my colleagues that are presenting today and making the event possible. So it's been a long journey and it's really great. I'd like to present some of the key issues addressed in my article on the European Union Guidelines on Human Rights Defenders, a review of policy and practice towards effective implementation. And I hope that these points will facilitate discussion. The EU Guidelines on Human Rights Defenders was established by the EU in 2004 as a policy instrument for European diplomats working in embassies in third countries to use to guide their engagement, support, and protection assistance to human rights defenders. EU member states have committed to varying degrees in bringing the recommendations and practical guidances set out in the guidelines into their diplomatic work. Thus, the guidelines provide an important document for ambassadors, foreign service office officials, foreign office desks, and human rights defenders themselves as a reference in considering concrete actions for human rights defenders' support and protection. So my article first looks at the practical use of the EU policy instrument since its revision in 2008, and how implementation of this policy has made an important contribution to facilitating support and protection to human rights defenders in third country missions of the EU. The article also addresses concerns of uneven and patchy implementation of the EU member states of these recommendations, which has been a long-going concern for the EU Parliament, who has reported on this, as well as international NGOs, human rights defenders themselves, UN reports, academic research, and many other commentators. Secondly, the article looks at how the practice of implementation of the guidelines has been effective and ineffective, with specific concerns raised from research that was carried out in 3 countries, Kyrgyzstan, Thailand, and Tunisia. And in the research, we were looking at the views of diplomats, human rights defenders, international NGOs, EU missions, and other stakeholders. Of those taking part in the research study, less than half responded to be fully aware of the guidelines' contents. The majority of diplomats in the study had not attended training that included focus on human rights defenders or the guidelines recommendations. And the research findings called for a further systemization across and within missions to make the guidelines recommendations better utilized. Thirdly, I looked at how the use of the guidelines is used as a policy tool to increase awareness of diplomats at the EU's policy to recognize and support human rights defenders as key actors in democratic processes and ways to support this role. The article makes a case for the guidelines recommendations to be embedded in and coherent with other external relation policy agendas of the EU and its member states, and in particular focusing on the cohesion of the guidelines recommendations when missions and European embassy diplomats prepare their EU human rights country strategies, and also human rights defenders' roles and rights-based approaches to development agendas, and considering human rights defenders in multiple sectors of EU and EU member state external relations. So due to the time limits of 5 or 6 minutes, I chose to draw an example as to how implementation of the EU guidelines has been successful and how these successes can be developed further to have relevance where human rights defenders may be most in need of protection. The example raises issues of approaches to promoting protection of the most vulnerable and hard to reach, accounting for and developing and sharing best practices across EU diplomatic missions, and the importance of embedding human rights defender engagement and guidelines recommendations in the human rights country strategy processes for sustainability and for knowledge transfer. So to give an example of a good practice that was reported by many diplomats in EU missions, when human rights defenders are brought to trial, the monitoring of hearings and trials by diplomats was reported as a good practice, ensuring fair trials, abuses will be reported on, and human rights defenders' cases are followed and raised as needed in important forums. Human rights defenders also saw this as a good practice and important action in implementing the guidelines recommendations. However, they highlighted the importance of detail in approaches to interventions, and in the case of trial monitoring, put forth some recommendations. When human rights defenders are on trial, trials should be attended by senior diplomats and multiple country representatives, as is possible, to show a level of concern about the case. There should be consistency in monitoring throughout the trial process. Diplomats should give attention to trials in outlying areas. It was suggested diplomats consider attending hearings in remote areas, signaling human rights defenders in areas outside of capitals are of concern and that all human rights defenders must have a fair trial. Diplomatic missions need to take timely action to raise cases when abuses, security risks, irregularities, or human rights violations are evident against human rights defenders or their families in the course of trials. And importantly, taking preventive measures, calling for adherence to human rights standards and challenging spurious laws and practices that criminalize and harm human rights defenders or their practice prior to the escalation of a human rights defender's arrest, detention, and trial. These suggestions may seem an arduous task to ask of diplomats, but when shared across missions, within mission sectors, and with other diplomatic partners, they have proven manageable. Such strategies and coordination brings in the need for embedding guidelines recommendations into the human rights country strategy processes. Human rights defenders that I have interviewed and worked with do find EU mission support vital to their engagement as active civil society members, particularly in countries where civil society space is limited or their legitimacy is threatened. However, in the countries of focus in this study, it was stressed support is often driven by particular individuals or small groups of rights-friendly diplomatic missions. When the individuals left the mission, human rights defenders complained that relationships to the mission and its support was lost. Some human rights defenders did not have knowledge of how to re-engage. Some embassies have taken steps to address this, but more missions reported that when diplomatic posts change, knowledge sharing of human rights defenders' work, maintaining relationships with human rights defenders of concern, and a process of documentation of intervention actions was a practice that could be improved in missions. So I look forward to further discussions.
Thanks. Martin?
Thank you. I'd like to echo Karen's thanks, both to the organizer of the event, but also, I mean, really to the organizers and the contributors to this process, because as you point out, it has been, as Laura's kind of alluded to in his introduction, it has been a lengthy process. And while I certainly haven't been at the center of it, I've found that my own thinking, certainly about what I'm about to talk about, has really benefited from all of the other contributions and the real genuine kind of sense of community and discussion within that community that has happened over the last 4 years. So it's been great. My contribution is really to look at a practice that's actually been around for a long time, that's known by a number of different names: temporary refuge, arrest and respite schemes, evacuation, as was mentioned earlier, or relocation schemes, what I describe as temporary international relocation initiatives, which date back certainly to the interwar period of the last century, but which have increased in recent years, both in a number of ways, in terms of the number of initiatives, their size, the geographic distribution of the initiatives, as well as their profile. And really my contribution tries to look at what I call these temporary international relocation initiatives and look at them as a response to human rights offenders at risk, and to look at them while also looking at their relationship with the international refugee regime. And there's kind of a personal narrative to how I bring, or why I bring together those three, but really I think the institutional one is probably the most important. As many of you know, at the Centre we run a protected fellowship scheme that brings human rights offenders at risk to York for a period of time, and it's been really a wonderful scheme, certainly from my point of view, but I hope also from the human rights offenders who participate in that point of view. I raise this simply because you don't need to spend an awful lot of time in and near one of these schemes to realize that actually many of the issues that these schemes, these initiatives deal with actually resonate very strongly with kind of issues that individuals dealing with refugee protection deal with. There's issues of access, of visas, there's issues of reception and integration, and there's issues obviously of voluntary return at the end, and kind of the formalities of possible subsequent asylum applications. I mean, bluntly, there is the reality that many individuals who go into temporary international relocation initiatives end up having to formally seek asylum. And so there is a very explicit, at least for a segment of the participants in these schemes, a very explicit link that I wanted to really explore. And I guess there's three observations that I would highlight in my article. I mean, and they may be trite, but I think they're worth saying, and I'll explain why I think that, and as well as link it to some of the other discussions that we've had already today. The first observation is that human rights offenders at risk are refugees, and refugees equally, conversely, can be seen as human rights offenders at risk. Certainly, human rights offenders at risk outside their country of nationality, country of habitual residence, meet the definitional requirements of a refugee, generally speaking, and have been recognized as refugees in the case law and also in practice. Although interestingly, there's a tension because the case law rarely identifies them as human rights defenders, possibly partly because of the novelty of the human rights defender term, but also possibly because of the reluctance of human rights offenders to themselves embrace the category of refugee. So I think there's an ambivalence also because of sometimes the stigma associated with being a refugee of the human rights offender community to embrace the term equally. In terms of the converse, that refugees can be human rights offenders at risk, we talk an awful lot about underrepresented or marginal groups of human rights offenders. We talk about women human rights offenders, we talk about human rights offenders working on land issues, environmental issues outside of the capitals. I think in many ways the situation of human rights offenders at risk who are themselves refugees, as well as refugees who are working on the rights of refugees, can really be seen in the same kind of ways as other marginalized groups. They're plagued by lack of status, they're vulnerable, much more so to destitution, to deportation, to detention. They're often not seen as working on what's considered a mainstream human rights issue, nor are they seen as part of the local human rights community. So I think kind of the observation that I would draw is that seeing human rights offenders at risk as refugees forces us to interrogate who we see as human rights defenders. The second point that I would make is that in looking for remedies for human rights offenders at risk, what temporary international relocation initiatives and refugee protection underscore is the need to look outside of the international human rights regime. Even using the word remedy to describe refugee protection, or for that matter temporary relocation, I think has been problematic for some individuals within the human rights community. It's not a remedy within the traditional human rights terms. And I think it raises many of the same issues as this discussion that we're having around protection mechanisms. The third point I make is that what temporary international relocation initiatives underscore is the importance, I would say the necessity, of civil society playing a role in both allowing access to state remedies, so in this case the international refugee regime, but also in creating parallel or mirror programs of protection that extend state remedies. Temporary international relocation initiatives very concretely often allow access to asylum through the facilitation of entry into jurisdictions where asylum can be claimed, but they also provide pathways of support for human rights offenders who subsequently enter into the asylum system. Equally, temporary international relocation initiatives provide the same kind of support, financial and otherwise, that in a sense refugee protection does. The final point I make is, I guess, just to say that for me, one of the interesting things about temporary international relocation initiatives is how it underscores, I think, in a way, the transformative potential of this human rights defender discourse. We talk about human rights defenders, and I think one of the interesting things is how it kind of underscores a different approach to how we understand the practice of human rights, one that is much less state-centric. And for me, temporary international relocation initiatives kind of underscores that by being a civil society response that exists both to support, but also to a certain extent in tension with kind of a more state-centric refugee regime. And on this last point, I would say that, clearly it's not a perfect world, and clearly temporary international relocation initiatives are a difficult topic to kind of fully embrace, because they are always going to be very selective. In the same way that the international refugee regime is selective. There's always going to be issues around resource allocation, and frankly, many of the biases, the structural biases that exist within the current state-centric system, the biases that require visas, for example, but on the other hand, the biases that, as we've heard, prefer kind of male lawyers from the metropolitan areas working on civil and political rights, also end up getting duplicated, and we have to be careful about that. So I'll end that.
Thanks. Lutz?
All right, yeah, thank you all so much. It's a great pleasure to discuss the three fascinating papers and presentations, which provide some really rich and also challenging conceptual and policy perspectives, and ask how they actually play out in practice. On the first presentation, I think very good, you have sort of an interactional approach, if you like, if you want to call it that, to look at also both sides of the equation, how human rights defenders identify themselves, and I think that's a theme throughout the various papers today, but also cast a light on how they are perceived by others. And I think we need to be in the mind of both sides, I guess, to get a better understanding of the local dynamics. I think that's a very important contribution. The broader question, I think we may want to open up for discussion, is also, should there be a broader debate about human rights defenders as a category, as a legal category, or is that futile? Or is an ambiguity actually beneficial, that focus more on how human rights defenders work in practice? Now, you said we need to move away from a positivist account. Now, maybe that's something that the Special Rapporteur may also want to focus on later on, because obviously if you work in an international system, you also need to work with normative categories. So, and I think there is a tension there between the normative standards on the one hand and the contextual approaches. So I think that is the key sort of theme that I take from your contribution. Now on the EU policies. I think it's a remarkable piece of empirical work you've done there, also working your way through all the different policies and how they have played out in practice. My broader question, is it also to do with the policies themselves, or are they coherent and sound, and is it just a matter of implementation on the ground? And I think here you highlighted a number of issues, and I think it would be good for all of you to share sort of good and bad practices that you know yourself. I think what is very important here is to look at some of the gaps and biases, not necessarily in the policies themselves, but on the part of the various actors and how they operate. And I think that was highlighted already, that the way diplomats work, the focus on the capital, maybe also the focus on certain types of human rights models or perceptions of human rights defenders, again, will then influence how they implement the policy or not implement. So again, the focus maybe on the well-known male lawyers, and also perpetuating certain models that may then even only inadvertently undermine protection. I think that's a very important question again to ask, to what degree these policies can be top-down or need to be more contextualized, and then the question to what degree diplomats have the capacity to actually do that on the ground, and also how that then clashes with other policy priorities, especially these days when it comes to the emphasis on security and also more and more on migration as well. And that leads me on to the third paper. I think obviously makes a very compelling case why human rights defenders should be recognized as refugees, but also rightly highlights a number of the dark sides, I think, with that approach. And here one of the key questions I see, what is also the potential backlash if there is a broader focus on human rights defenders as refugees? Would that then take us back to this whole question of how to define human rights defenders, and given the sentiment that we know, the question of asylum seekers triggers, that would then most probably be a rather narrow definition that is used. So that might actually, again, drive a wedge between different categories of human rights defenders and create new hierarchies. And also, final point, obviously, on the temporary relocation initiative or settlements. Again, I think one can talk a lot about the practice, and I know the frustration of a lot of human rights defenders of accessibility, and I think there's a lot to be done, and that ties right in with the EU policy as well. But one of the bigger questions for me is, well, a lot of the human rights defenders obviously do not want to leave. They want to go back as quickly as possible, and by using the refugee model, are we not, again, inadvertently, in a way, perpetuating the situation? Are we not actually doing the bidding of the repressive regime that, and in a lot of cases, they may be quite happy to see people leave and obtain asylum elsewhere? So I think there's a lot of challenges that all the three papers raised, more questions than answers, but certainly I think also a lot of good thoughts on where to take it from here. Thank you.
Thank you very much. It's my great pleasure to introduce the Special Rapporteur on Human Rights Defenders. If you didn't know who he was, well, you're maybe at the wrong event, but thanks for sticking around anyway. Let me turn it over to Michel Forst.
Yeah, thank you. Although I've not prepared any statement for tonight, I just wanted to thank you, all of you, for the invitation. It has been extremely interesting for me to listen to the presentation, and also to read the special edition on the protection of human rights defenders. And I remember that we first discussed that at one of the meetings that I organized in Florence with experts, to which James, Savage, and Enrique were invited to participate into as experts to provide information and sort of ideas on how I could manage with this mandate to present to states means of protection for defenders. And I've been tonight again extremely interested by the short presentation, the format of the discussions, and I see that there would be many additional questions or things to say on each of the presentations after the reading of all the papers. We already discussed with James and with you the possibility to do additional research on some of the themes that were tackled in this special edition, especially on the need to do a proper and more in-depth assessment of the effectiveness of the EU guidelines. I would say it's not only the issue of the EU guidelines, but also other tools that have been invented by states to protect defenders. I was in October in New York for the presentation of my report, and I also went to DC to speak with the State Department, and I discussed with them the US guidelines and the lifelines, the means of protection that they have developed, and I told them that as we want to evaluate, do an assessment of the EU guidelines, would you also be willing to look at the possibility to assess and to do the evaluation of your own protection system? And said, yes, we don't have the means to do that, but if you want to do that, please do that. So, but I do have the foundation for that. But I need to find researchers, academics that will be willing to work with me to do a proper assessment of the means of protection. Just also wanted to share with you the fact that we, meaning my colleagues, Special Rapporteur and myself, we meet every year in June to discuss working methods, and at each of the sessions we discuss the needs that we have to get additional information, to receive information, to unpack also concepts that we don't have the time to do so. Some of us, some of the Special Rapporteurs are already law professors, they have their law clinics, they can do that, but many of them don't have the possibility to have access to academic research, and that's useful for them to know that the network and others will be also willing to provide academic research for those of my colleagues that would need additional research. In fact, listening to the short presentation, I also have in mind a lot of issues that I would like to discuss with the academics, and we don't have time to discuss that tonight, but please believe me, I will come back to James, to others with a request to do additional research on many issues that I want to unpack to make sure that my presentation before the Council and before the UN General Assembly would be well informed, not only by the information that they do receive from defenders and from civil society organizations, but also by informing them by other sources, and academic research is probably a tool that I need to further explore to make sure that my mandate will be more effective. So thank you.
Great, thank you very much. It's just left to me to thank you all for coming. I encourage you to take both special issues. They make wonderful stocking stuffers at this time of year. And we also have a reception at the back where you can engage the authors, and I know Michel has had two, I think, whirlwind days here in London. So if he's up for it, you can always color him as well. Thank you all very much, and thanks again to the network.